All right, we're at 9 o'clock, so we are going to go ahead and get started. My name is Matthew Scully. I am a partner in the Birmingham office in Burr Labor Employment Group, and I'm joined with Chandler Aragona, who is an associate in our Burr Charleston office. Appreciate everyone attending today. Topic of this presentation will be New Year and New Employment Law Issues, Key Legal Developments to Watch for in 2024. Next slide. So, in all my years of practice, these are some of the biggest changes I've seen. And what's good for us lawyers is probably not good for you guys who have to comply with the law. But what we're going to do is we're going to cover these big changes. And some of them are from 2023, but they either haven't gone into effect or we've gotten more guidance in 2024. And we want to emphasize those with you. What we're going to cover today is the DOL's proposed increase to the salary threshold, the NLRB update, use of AI, the DOL independent contractor rule, and religious accommodations. So we've got a lot to cover in this time, so we're going to jump right into it. All right, DOL's increase to the overtime pay threshold. So you probably heard about this last year. As most of you know, I hope on this, there's a law called the Fair Labor Standards Act. The Department of Labor enforces it. What it says effectively is that non-exempt employees are entitled to minimum wage for all hours worked and overtime for time worked over 40. Exempt employees, on the other hand, are not entitled to overtime for time over 40 hours. How you determine if someone is exempt, it's a two-part test. You look at how much they make, and then you look at their job duties. And do they fit within one of the exemptions, administrative, professional, those type categories? What the DOL has proposed to change is not the duties test. What the DOL proposes to change is the salary threshold to be exempt. Why this is important is because if someone doesn't meet this salary threshold, they're entitled to overtime. So they could meet every job duty that you would want to meet to be an exempt employee, but if they're not paid this minimum threshold amount, then they're not going to be exempt. And it's black and white, it's objective, either you are paid that much or you aren't. So you may remember in 2020, this change, it used to be they got to make $455 a week. That jumped up to $684. And that means they would earn that regardless of the quantity and quality of their work. It was a guaranteed amount that they would get every week. That jumped up in 2020. Also, as part of the 2020 changes, they allowed employers to consider non-discretionary bonuses up to 10% in that total amount. Well, the proposed change now is an increase from $684 per week to $1,059 per week. And that changes from a little over 35,000 to a little over 55,000. So this is a pretty seismic change. Department of Labor estimates it'll impact 3.6 million workers. And so if you have any persons who are not receiving overtime who would make under $55,000 a year, this impacts you. And this change will impact you regardless of what this person's job duties is. Now, I've also made a change to the highly compensated test, going from 107,000 to 143,000. What this highly compensated employee tests are, usually they're going to be exempt anyway, but highly compensated means that it's not as stringent of job duty requirements to be exempt if you're making that much money. What currently is 107,000. Next slide. All right. How did they come up with this number? So they looked at in the proposed rule. It's based off the 35th percentile, the average weekly earnings of full-time salaried workers in the lowest wage census region, currently the South. So that's where they came up with this number. And the number is higher now than it was when they first proposed the rule. The DOL used 2020 data. And now based on, as probably all of you know, wage inflation. It's currently would be 60,000 if they use the current numbers. And this matters because there's a mechanism that will automatically update the salary threshold every 3 years. So just getting to 55 now doesn't mean you're going to be safe 3 years from now. So this is something that's going to be have to be constantly monitored. In the past, there was not this automatic threshold increase. So that's a new development to be thinking about. Next slide. All right, so the status. So you're probably thinking, well, I heard all about this last year. Why are we still talking about it? So comments closed in November, and they received 33,000 comments, which is an insane amount to receive on their proposed rules. It's the most I've ever seen for something like this. The DOL has indicated that its regulatory agenda setting for April 2024 as a target for the final rule. And the final rule is that the final rule. It's the rule that will govern how this works. And then once that final rule goes into effect, so it's entered April, and but for a leap year, we'd be in April, we'd be in March, a month away from April, and then 60 days, everyone's got to comply with it. We expect legal challenges. There were legal challenges last time when there were changes made in 2016. An injunction was entered stopping the rule. The proposed rule. It did not go up through to the appellate courts, Supreme Court. So we don't know how the higher courts will rule, but we certainly expect some legal challenge as soon as this final rule goes into effect. Next slide. All right. So what can you do right now? We recommend understand your workforce, and that means understanding how many employees you have above 35 but below the 55,000 threshold, because those are going to be the people who are impacted. People who are currently under 35 right now, I sure hope they're being paid overtime. But this group of people between 35 and 55, figure out who's covered and figure out if there's any bonus issues you need to think about or any more complicated analysis to this, like a non-discretionary bonus they get each year. And do that to understand what your risk points are. We then recommend employers can look and track how many hours these people are working. If you've got a person making $50,000 right now who's working 60, 70, 80 hours a week, there's probably a lot of exposure there, particularly if you have a lot of people in these positions. If you have these individuals who are working around 40 hours, less exposure is still important, still something to think about, but at least you can wrap your head around the issue. Because when this final rule comes out in April, things could happen really fast. And we recommend everyone get in front of this and understand risk, cost, how we're going to have to change, and how to handle employee morale. Because there's two ways to deal with this. You can bump people's pay up to get them above 55. That obviously creates wage compression issues that you have to deal with, or you can make them hourly. And that creates its own issues because a lot of these exempt employees are proud of being exempt and they don't like being hourly. And there's ways to message it in a positive way, but that's something you'll have to decide. And we, of course, can help with messaging, legal communications, things of that nature. I also recommend reviewing policies, clock-in procedures, off-work procedures. A lot of these exempt employees are doing work at home, outside normal working hours. How is that going to change now if they're becoming hourly? How are you going to track that time? How are you going to communicate to them how to keep track of time? Those are all things you need to start thinking about right now.
Okay, so I will take over the artificial intelligence in the workplace topic. Artificial intelligence is an emerging technology that is really revolutionizing industries across the board, including the human resources industry, which I'm sure has probably affected most of you some way or another by this point. AI can be used in employment in HR through administrative support, recruitment, training, onboarding, employee wellness, and talent acquisition. And while AI can certainly create efficiency in these areas, the efficiency that it does create doesn't come without its risks. So one concern which has been highlighted by the EEOC is that by utilizing certain algorithms in hiring and screening technologies, employers may be creating an adverse impact on protected classes. And examples can include resume scanners that are looking for a certain keyword, or chatbots that ask applicants about their qualifications, and reject those that don't meet the predefined standards, and testing software that scores applicants based on personalities and cognitive skills. So the EEOC created a technical assistance document to discuss the adverse impact issues created by AI technology and hiring processes. It just reminds employers that they're not off the hook for liability just because these decisions are not being made by human beings or because software was created by third parties. And a lawsuit has actually already been brought in California in which the plaintiffs are alleging that the screening tools allow for pre-selection of applicants outside of protected categories. So the EEOC advises that employers conduct test runs or actually analyze the decisions that are being made by this AI technology to ensure that they're not creating an adverse impact under Title VII. Use of AI in performance management can cause similar concerns with lack of human oversight, especially if you've got a disability or another protected characteristic which is hindering the employee's performance. So be sure to include actual human feedback in performance evaluations and in making promotion, demotion, and termination decisions as well. Other issues created by AI technology are automation of job functions, eliminating jobs as a whole, reduced human interaction in the workplace and in customer service, and privacy concerns with employees inputting confidential employer information into these AI technologies. The AI platforms will retain the information that's put into it, and this can cause additional concerns with private health information and genetic information. So be sure to thoroughly review any agreements that you may have with third-party AI platforms. Privacy breaches with respect to AI could be covered by your current policies with respect to confidential employer information or social media, but it might be worth taking a look at those and addressing whether or not you want to add additional language, given the nuances that are posed by this new technology. Okay, Matt, Pregnant Workers Fairness Act.
Okay, great. So this is the EEOC enforces this law. This is a new law. It went into effect in July. So if you're not complying with it now, you need to. The EEOC was supposed to issue a final rule on this in December, or final regulations in December 2023, but it's missed that deadline. So why this is a 2024 issues is we're expecting some EEOC final regulations soon. We don't know when, and that could change parts of this. So stay tuned for that. But I think it's important that everyone on this Zoom call understands what this law and generally what it means right now. And this is hot off the press. 2 days ago, a federal court in Texas enjoined this law. It enjoined the law as it applies to Texas, so this doesn't apply to everyone. But the reason it enjoined the law, it said that there was not a quorum to pass the law. It's a 120-page decision about congressional quorums that I will never read, but I can tell you what I've read about it, and that when the law was passed, this Pregnancy Workers Fairness Act was part of a broader law. It passed under COVID regulations for voting, and the federal court in Texas, in that long opinion, said that that was not appropriate for the passage of this law. So it stayed in Texas. It's not as applicable to the state of Texas. It's not stayed in other capacities, but you can be sure there will be many copycat challenges. So we'll be keeping an eye on that. But Pregnancy Workers Fairness Act, I think to understand it, it's helpful to talk about why Congress felt it was needed, because there are a number of laws protecting pregnant employees that already existed, but there was a gap in coverage, and that's what this new law seeks to fill. Under Title VII protects an employee from discrimination based on pregnancy, childbirth, or related medical conditions. So you can't fire someone because they're pregnant. You can't demote someone because they're pregnant. You can't treat them differently because they're pregnant, childbirth, or related medical conditions. Title VII, though, is not an accommodation law. Title VII doesn't require you to treat people better. It just requires you not to discriminate against people for these protected classes. So there was some protection to pregnant employees there, but not full protection. So you're probably asking, well, the Americans with Disabilities Act, that's an accommodation law, and you'd be correct. You can't discriminate against people based on a disability, and you must provide reasonable accommodations. The issue with pregnancy is oftentimes it's not considered a disability. Another drawback of the Americans with Disabilities Act is you have to be able to perform the essential job functions. So if you can't do the job, then with or without a reasonable accommodation, then the employer doesn't have to accommodate. There's an undue burden defense that employers can put up, and there's a number of steps that are part of the Americans with Disabilities Act process for granting an accommodation. Where there was a gap, I think what Congress saw is that a lot of pregnant individuals are not disabled under the ADA definition of disability, and accommodations oftentimes are needed in their short term. Be off work, can't do certain job functions, and employers could take the position, well, those are essential job functions. We don't have to remove that lifting restriction for you, pregnant employee, because that eliminates an essential job function. So while there was some protections there, it primarily came up in real complicated pregnancies, and it usually involved the employer saying, well, you just need to take time off. That's the accommodation. You can't do the work. We're just going to make you take time off. And so again, some protections, but not as much as our elected officials thought should be there. Asking about the Family Medical Leave Act. Yes, that's a law that pregnant employees can take advantage of. Complications from pregnancy and also bonding after birth of a child. But this only applies to limited employers, 50 or more employees within the 75-mile radius. There's a process. It's not there's not a great connection for pregnancy, intermittent pregnancy. I need to sit for a little while, pregnancy. I need more frequent bathroom breaks. There wasn't a good fit for those type situations under the Family Medical Leave Act. Then, of course, there's Pump Act. Pump Act is broad workplace protections for employees to express breast milk at work. That has a more narrow lane and does not catch a lot of the issues that could come up with pregnant individuals. So because of all that, what do we get? We got the Pregnancy Workers Fairness Act. And so it went into effect in June 2023. It applies to all employers with at least 15 employees. And what it ultimately says is that qualified employees who are limited due to pregnancy, and what limited means is limited in any way. There's not a specific level of limitation. It could be minor, it could be modest, it could be as long as it's related to their health or seeking some sort of medical treatment related to pregnancy, childbirth, and related medical conditions. That's a limitation. It could be, I need to sit down for a little while. It could be, I can't lift this. That's a limitation I have. It could be, I need time off. It could be anything, but it's any sort of limitation that's created. And think as broad as you can, because that's how the ESC is going to analyze this. Any limitation caused by pregnancy, childbirth, and related medical conditions is covered, as long as accommodation does not create an undue hardship. Any of you who've dealt with Americans Disabilities Act and undue hardship, it is extremely hard to prove an undue hardship. Oftentimes they're going to look at cost. They're going to look at impact to the bottom line of the company. And especially as these companies, as you get with a bigger company, it's going to be really, really hard to show giving this an employee an accommodation for 20 weeks until the pregnancy is going to impact our bottom line, or it's going to cost us hundreds of thousands of dollars. It's really hard to prove. And, very rarely do we even argue undue burden on accommodation issues. ADA, what we usually argue is it's an essential job function. For example, if someone is a delivery driver, they have a medical condition under the ADA that they can't drive, and they ask for an accommodation, we can say, well, driving is an essential job function. If there's no accommodation we can give you that would allow you to drive, then it sounds like you can't perform the job, and then the employment ends. And that's a way to think through these ADA accommodation requests. That's not how this law works. And I've heard HR, I've even heard attorneys Well, this is just an ADA for pregnant work for pregnant individuals. It's not that. It's not that at all. It's much more detailed. It's much more onerous. It's much more burdensome. It involves a lot more commitment by the employer because if they can't perform the essential duties, that doesn't matter. You still got to accommodate their limitation. If that job requires driving, then you may have to find them a light duty. You may have to, and they can't drive because of their pregnancy. Doctor says you can't drive. You're going to have to find something for them. You're going to have to find light duty work. You're going to have to focus on desk jobs. You're going to have them call on people instead of driving. You got to come up with something. And you can't just tell them to go out on leave because that's expressly stated in the ESC proposed regulation. So telling people, sorry, that's part of the job. Why don't you take time off is no longer going to be answer to these pregnancy issues. So ultimately, if the employee has a known limitation, and that would be they communicate it to you, you don't want to assume someone's pregnant or has a limitation because of they're pregnant. But if they say, I have a limitation, and there's no magic words, just I'm pregnant, my back's hurting. I'm pregnant, I need to rest some more. That's enough to get into this realm related to pregnancy, childbirth, or related medical conditions. We'll talk about that next. Then you're in the realm of reasonable accommodation. And that's when you have the interactive process and you figure out what we can do to make this work. And I implore you, you need to figure out what you can do to make this work because very, very rarely, unless you can show undue hardship, will you be able to say, sorry, we couldn't accommodate that situation. All right, so the EOC has issued some proposed regulations. Again, we're waiting on the final regulations. It uses some of the concepts from the ADA, reasonable accommodation, but there's no essential function requirement. It does use the undue hardship component. Interactive process, that back and forth, same thing. Confidentiality requirements, same thing. One part it does change that I think is a really, really big deal is under the Americans with Disabilities Act, oftentimes when employees come to you and say, well, I need an accommodation, I have this condition, you can require medical documentation. You could send the employee to the doctor with the document saying, hey, can this employee perform the essential job functions? You can get a lot of information. You can fully understand the situation, you can understand better how an accommodation will work, and you can have that conversation with the employee. Under these proposed regulations, that's not how this new law works. It sets out a number of examples where you just have to give, if the employee's pregnant and asks for this sort of accommodation, you just give it to the employee. You can't ask for medical documentation. Now there's certain more complicated conditions that you could ask for medical documentation, but those are going to be very fact specific. So as we're talking about how this is different and why this is not just ADA for pregnant employees, the rules are different, and particularly in terms of what information you can get. Now you may be thinking, well, I can deal with pregnancy. It's a lot more than that. It's pregnancy, childbirth, and related medical conditions. So what does that mean? Current, past, and potential pregnancy, lactation, use of birth control, menstruation, infertility, and fertility treatments. Probably heard about a big decision in Alabama, or at least recently, about infertility and fertility treatments. That's covered under the PWFA. Endometriosis, a miscarriage. If someone dealing with consequences of a miscarriage mentally, that could be covered. Stillbirth, having or choosing not to have an abortion. So when you're thinking through these things, it's not just the showing pregnant employee. There's a lot more to this. And so you've got to think about it in a broad sense. Next slide. You may be asking, well, what are these job restructuring? You've said we got to do something. What are some examples the ESC proposes to accommodate people? Job restructuring, part-time work. Light duty, that is an accommodation, light duty. It's not under the ADA. Under this law, it is. More frequent breaks, buying them special equipment, uniforms, devices, seating for jobs. Use of paid leave, providing unpaid leave, assignment to light duty, telework. Don't rule out telework when you're going through this process. Suspending essential job functions. Okay, you don't have to lift the 15 15-pound box that has to be lifted twice an hour. We're going to have someone else come and do that for you. So whenever the 15 box comes in, let us know. We'll have someone else do it. Those are things you would never have to do under the ADA. Under this law, that's something you need to do. And why this is, I think it's so important, is this law may have not have received the attention it deserves. And hopefully you as HR professionals know about it. But there may be situations where your supervisors don't. And your supervisors are used to a world where they live in, where they kind of understand how to deal with pregnant employees. And if it's complicated, well, I'll involve HR. But what they may not know is if there's a pregnant employee and that employee says, hey, I'm tired, I need a break, that's a legal issue under this law. And I think it's really, really important that there's training with supervisors about this law. Not that they have to be experts on it, but they need to be able to spot issues and know when to bring it to you for questions and concerns. Next slide. All right, so just kind of recapping PWFA, you cannot require an employee to accept an accommodation without a discussion about the accommodation. So that's that interactive process. They can't say, well, I want A, and you say you have to take B. You've got to have a back and forth with them. You got to understand the situation. You need to figure out something that works with everyone. It's a little unclear to me right now if they get what they want. If I want this accommodation, they get it. I think my interpretation of it so far is that you need something that fixes the issue. If I need to sit for 10 minutes each hour, you let them sit for 10 minutes each hour. You don't have to give them, if they say, well, I want to sit the entire shift, you can say, well, if you need to sit 10 minutes, and we'll let you sit 10 minutes. But this is a gray area, and I think you need to be very careful with those type situations. You can't deny a job or any opportunities because of a need for reasonable accommodation. So pregnant employees, promotions, transfers, anything they would normally be entitled to, you don't want to hold this against them that they've asked an accommodation. And requiring an employee to take leave if another reasonable accommodation can be provided. So you can't say, as I noted earlier, well, it sounds like you can't do the work. Why don't you just go home, recover, or go home, rest up, have your baby, and then come back to us when you're ready. We'll hold your job. You can't do that anymore. If they want to work and they propose you a way to keep working, light duty, part-time duty, you need to do it. You can't just say, you got to take leave for this one. You obviously can't retaliate. It's the same type of laws, retaliation. They're in a protected class. And I think that's something to think about with this. You may have coworkers. Why does that person get to sit? You may have supervisors. Ask this person to do the job. Every time I want them to do the job, they say, oh, they're tired, they can't do it. Things like that can create animus, create perceptions, and can create retaliation claims. So again, part of that training we were talking about, that's why I think it's going to be so important. Can't interfere with any individual's rights under the PWFA. One part of this, if you haven't already, I think everyone needs to update their handbooks to have a specific section about pregnancy accommodations. One, it'll help legal defense when claims are brought. Two, it's probably not in your handbook if you haven't amended it since July 2023 when this law went into effect. And three, we want employees to know when they've got questions to come to HR. And that's what your handbook would say. If you need accommodation, come to HR and HR will work with you. Kind of takes out that supervisor from getting involved in a situation that they're not as comfortable with. It comes to you with HR. It's in the safe space, and you can work with them on the appropriate lawful accommodation.
Okay, so the new DOL independent contractor rule. So with respect to wage and hour issues, the 2021 Trump-era DOL independent contractor rule made it easier for employers to classify workers as independent contractors. And this 2021 rule placed greater weight on the control over the work and the opportunity for profit or loss. The 2022 rule is more employee-friendly and focuses on economic realities, analyzing these 6 factors. The new rule becomes effective on March 11, 2024, and much of this new rule incorporates the pre-2021 legal landscape. So there's little substantive change for employers who continue to apply the pre-2021 test their analysis. So if you had analyzed any of your business worker relationships pursuant to the 2021 rule, you may want to take a second look to ensure that you've got correct classification under this 2024 rule. Matt, do you have anything to add on that?
No, I don't.
All right, and lastly, we are moving into religious accommodation. As I'm sure you all are probably aware, under Title VII, employers with 15 or more employees must provide a reasonable accommodation for an employee with a sincerely held religious belief, unless the accommodation would create an undue hardship. The precedent was set in 1977 when the Supreme Court held that an employer was not required to accommodate an employee's request to observe the Sabbath. In June of 2023, the Supreme Court revisited that 1977 precedent when an employee requested off work to observe the Sabbath. And the Supreme Court held in Groff that an employer had to show more than just a de minimis cost in order to show an undue burden, sufficient to deny the employee's request for reasonable accommodation for that sincerely held religious belief. An employer must now show that they will experience a substantial increased cost in relation to the conduct of the company's particular business. And the Supreme Court really did not give an example of what type of increased cost would satisfy this standard. All we really know now is that it's more than just a de minimis cost. We've got to show a substantial increased cost. The EEOC previously issued guidance on this issue, and the court indicated that this guidance could still be followed because the employer will need to demonstrate how much cost or disruption the potential accommodation would cause in order to show undue hardship. So we can still rely on that previously issued EEOC guidance, even in light of this new Supreme Court opinion.
And I think it's important to note that the EEOC may revisit their guidance because that guidance was issued under what it thought was an old standard. And so we can expect, I would think, something new from the EEOC on this because this is a really big change. Anyone who's dealt with religious accommodations in the past, that de minimis standard was a really helpful standard. If someone didn't work on Sunday, you could say, well, need you to work. If you can find someone to swap shifts, fine. But courts had held that would meet the de minimis standard. Under this new ruling, I don't think it would. But it's not clear, and it creates a lot of ambiguity in what's going on. So when you receive the real import of all this is when you receive a religious accommodation request, how you used to analyze it is not going to be the same. How you need to analyze it is not entirely clear, but it just needs to get a more focused attention, and you'll certainly need to do more than you had to do in the past.
Right, so here is the current EEOC guidance, and as you can see, much of these accommodation ideas relate to schedule changes. So we can still take a look at this guidance for now, but as Matt has stated, this is likely going to change given the new standard. So these are just some general tips. Oh, go ahead, Matt.
I saw a question pop up, so I'll jump in and answer that. It's a good question. So is it sufficient to grant the request but require them to work before and after the scheduled service? So the answer to that will depend on their religious beliefs. The way this law works is we are very limited in our ability to question their beliefs. If it's sincerely held, then we need to figure out how to accommodate. And so if someone's religious belief is that I need to be at a service, then yeah, you can work with them. Well, I want you to work before and after. If someone's religious belief is I can't work that entire day, then that's different. You would need to work with them separately. But yeah, if they come to you and my religious belief requires me to attend this service from 9 to 11, okay, we'll come in before and come in after. That would be a way to do this. Or if there's a when someone requests time off, you have them go through the normal process for paid time off. Handle it that way. But to answer your question, yeah, as long as it doesn't conflict with their religious beliefs, you can have them work before and after.
And these are just some general tips to consider when reviewing and thinking through a request for a religious accommodation, even the new Supreme Court case. We just have to remember that an employer has to show substantial increased costs at this point. And again, we're not quite sure how to analyze that, but I'm sure the EEOC will give us some new guidance shortly. Matt, I cannot see if there are any additional questions. If there are at this point, we could take some.
We have there's one more slide set if you go, keep clicking through.
Okay.
And so I just want to touch on this briefly. The National Labor Relations Board, if you could bump to the next slide. There's a lot going on with the National Labor Relations Board. We could make this an hour presentation. Some of you who are dealing with union issues right now or organizing activity right now, you're probably well aware of this. What I want to emphasize, though, is this applies to union and non-union employers. So just because you're not unionized don't think these changes aren't impacting you. There's been a lot of changes, and we're expecting more changes. The three biggest ones I think that'll be helpful to think about right now are a broader definition of protected concerted activity. So protected concerted activity, if two or more people are acting to improve terms, working conditions, wage, that can be concerted. One person acting on behalf of others to improve terms, working conditions can be concerted. So group complaints, we don't like our supervisor, it's too hot here, we need to be paid more. All those things can be protected activity, and people can't be retaliated against for that sort of activity. That definition is getting broader and broader. There's a recent decision by the National Labor Relations Board. An individual wearing a Black Lives Matter patch on their shirt at work was protected concerted activity. And so the employer cannot tell that employee to take it off. And so it's getting into a realm where there's things that may be on the periphery of group activity to improve wages, working conditions are being protected. So I tell you that when employees are acting jointly or acting for social causes, think carefully about how you're handling that, how you're processing that. The simple response is, we don't allow political stuff on any of our shirts, may not cut it anymore. If it's a shirt about social change that could impact the workers at the plant. These decisions like that will probably be reviewed by an appellate court at some level, and we'll get more guidance, but know that part, because that's one part. The other part I want to talk about is handbook. So there's a new the way the NLRB is analyzing work rules is differently. And frankly, and I'm not just trying to scare everyone, but anyone who has not had their handbook changed this year probably has an unlawful handbook under the NLRB, because there's so many policies that are now overly broad. And what that means, the application of that is you would get an unfair labor practice charge, and you'd ultimately have to change the handbook. There wouldn't be a monetary penalty. So it's not the way the federal government's going to come on me and I'm going to have to pay millions of dollars because I have a handbook not correct. But it's something we think employers need to change. There's organizing activity. Can be very hard to take certain steps if you don't have the right rules. Disciplining people if you don't have the right rules can be very hard. And so we recommend everyone look at your handbooks. I don't know when most people do it, end of the year, beginning of the year, whenever they get time to it, but this would be a good time to look at that, especially putting in the new pregnancy policy. There's things to do now that we can help you out with to update your policies. And it may not even need to be a full review. It could be, can you update it to get it compliant with some of the latest? And we expect more union-friendly rules. It's an administration that says it wants to be the most union-friendly administration. The National Labor Relations Board that has far and away been the most union-friendly National Labor Relations Board we've ever seen. Organizing union activity, it's the most organizing activity we've ever seen, and it's not even close. And so this is something that everyone needs to think about. It's not a new law for 2024, but it's a new period where the unions are more aggressive than they've ever been. and we've left some time for questions. We'll give it just a few seconds, but if there aren't any, we really appreciate everyone being on this Zoom call. I hope it's been helpful. It's been high level overview, of course, and we're always available if you want to email us to answer any more narrow questions. But these are some big changes, and I really it's not always like this each year, and so I hope everyone has paid attention to what we've been talking about because there are things that could lead to litigation. There's things that could really change how you do business, and it's important to be thinking about those issues right now. It looks like, okay, so we've got a question about when did the actual change come into effect for the NLRB? So the changes to how handbook rules are interpreted was late last year. So that's when the NLRB decides something, it goes into effect. There's not proposed rule and comment periods. The NLRB makes its decision. It is what it is. Most of the guidance we have right now, or the decisions by the NLRB, are in effect right now. That decision I told you about, the social justice, putting things on your shirt, that's an NLRB decision. So that's in effect now. That's how the protected concerted activity is interpreted. So these changes with the NLRB, they're going into effect now, and so you need to start thinking about now how to deal with them. So the FLSA ruling we talked about. So there will be a final rule. The agenda says April. We don't know when. I would not put it past our government to delay the rollout. It wouldn't be the first time. As we talked about the PWFA, EEOC was supposed to put out regulations in December and didn't. But April is when they said they want to put it out. From that time period, it's 60 days until there's a 60-day grace period, I guess you would call it. But after that 60-day period, if there's no injunction, no filing that stops it, then that's the world you're living in right now with these changes to the pay. Question, yes, about classifications, exempt, non-exempt. Yes, yeah, that's something we do. So the question was, we've got some employees, they may be in a danger area, whether that's job duties or pay. Do we offer service? Well, we'll look at that and give our legal advice on how to classify them. Yeah, that is. We've got a process. We've got documents we use. We've got checklists. We can take your people, the group of people you're worried about, get a document together and give our legal opinion. It would be attorney-client privilege protected about, here are your 3 big risk points. We feel pretty good about these 3 or 4 people, and get you in a comfort level with understanding where you stand if the Department of Labor came in, or if you got a lawsuit, a wage and hour lawsuit. And yeah, the slides recording, I will defer to Grace and Michelle on those, but I think they are made available if I recall.
I believe they are.
Okay. All right. Well, those were all very good questions. We appreciate everyone being on the call today. And like I said, call me, call Chandler anytime. We can help answer any questions you have about these things.